Hello, hello, good morning. Thank you for being there. Well, we are going to try to continue with the course through this new tool, a video. As you know, we are not going to have face-to-face classes in the next weeks, and we are going to do our best in order to continue with the course of International Commerce Law. So, as I have explained to you in my previous mail, the idea is that I'm going to share with you some videos with explanations, and at the end of the video, there will be a task you should do. You should answer some questions in relation with a case, and then I will give you feedback through another video. First, my apologies. I am at home, so this is not perfect from a technical point of view. I'm using my own computer, and my wife and my children are here at home. So, if in any moment you hear something that is not very common, it's probably some member of my family making some noise. But well, this is the circumstances we are facing, and I'm sure that we are going to deal with them the best we can. So we can maintain also our contact through email, and I think that it's also possible to have tutorials by Skype. I was trying this morning to use my institutional account in Skype, the account of the university, but I couldn't introduce this account in my own computer. I guess that only in the computers of the Universitat is possible to use this account. So I will share with you my personal account in Skype, so it will be possible to have some direct contact through Skype. The best is that if you have any doubt and you think that it's better to resolve this doubt through Skype, please send me an email, and then we are going to find a moment to have a Skype conversation and to resolve the doubts. And probably in the next days we are going to change things, because we are trying to find the best solutions for the situations we are facing. And some other practical questions. Of course, next week we are not going to have the practical exercise that was scheduled, and we are going to change this exercise for another kind of exercise that could be done through online. I'm not sure now what we are going to do, but in the next days or maybe next week, I will provide you with information about that exercise. So the idea is that we are going to continue with the classes through video, mail, Skype in some occasion, and we are going to change the exercises in the classroom for exercises online. And at the end, the idea is that even in the case that this special situation will continue for weeks, or months, we don't know. I hope that it will be only weeks, but we are not sure at that moment. So in any case, we will be able to end the course. I think that fortunately we today have a lot of tools online, and the communication, it's easy. This morning I was dealing with issues related with the faculty through email, and I think that everything was well. So maybe we are able to do a lot of things online that we haven't realized till now that this was under our possibilities. So I'm not sure how long it's going to be this video. Of course, it's not going to be 3 hours. I guess that in the case of a video of 3 hours, I will have problems even to share this video online. It will be shorter than that. We are going to deal only with the part of unfair competition. That is the next part in the program. Well, in fact, in the first moment, international designs, and then unfair competition. And after this, I will explain to you the exercise you are encouraged to do. And my idea is that on Friday, I will share with you another video with the last part of this lesson 2, a video with the products liability issues. And then next week we will see what we are going to do. The next lesson is company law. Probably I will share with you another video or 2 videos with issues of company law and so on. So international designs. In the last session, we have seen that we have ended with trademarks, and I have explained to you that the international designs are following the same principles than trademarks. So in international designs, we are going to focus in the situation in the European Union. We have the same situation than in international than in trademarks. Sorry, I'm trying to find a web page now in my computer, and I'm realizing that I'm not able to do that without moving the camera. Oh yes, I think that at the end I could do that, hopefully. Let's wait a moment. It's difficult to find that, so I should do that another way. Well, international designs. We have harmonization in Europe. We have a directive 98/71, and this directive establishes rules that should be introduced in the domestic law of each member state. This is one of the approaches. We have different national laws in the European Union related with designs, with commercial designs, with designs used in industry and in commerce, and there is, as we have seen till now, different property rights, intellectual property rights, with a territorial scope, a scope limited to the territory of one country, and this is one of the approaches. And the other approach is we have also European Union designs. This is in Regulation 6/2002, and this is a regulation that develops the same functions in relation with designs than the regulation on trademarks, on European Union trademarks, that we have seen last week. So we have here a intellectual property right in designs, a design, and the territorial scope of this design, of this intellectual property right, is the whole European Union. The same we have seen in trademarks. The idea is the same. The idea is that we have, in one hand, the national designs, and on the other hand, we have a European design that you can apply for it in Alicante. The office for the European design is also located in Alicante. It's the same office that the European trademarks. And when you have this design, this European design, you have an intellectual property right that covers the whole European Union. And the regulation in designs follows the same philosophy, the same ideas than the regulation in trademark. For example, we have seen that in trademarks that as we have an European Union trademark with a regulation at a European level, but this regulation must be complete with a national law, we must determine which national law are we going to consider in order to complete this regulation of the international trademark. And we have seen that in trademarks there is a regulation making equivalent this European Union trademark to the European Union of a national level in order to complete the regulation. We have here the same in the community designs, in the European Union designs, in Article 27 of the Regulation 6/2002. We see here that a community design, a European Union design, is considered as a national design right of the country, of the member state in which the holder has his seat or his domicile. When there is no seat or domicile of the holder of the design, of the right in the European Union, we are going to consider the country where this holder of the design has an establishment, point B of number 1 of Article 27, and in the case that this cannot be applied because there is no seat of the holder of the design in the European Union and there is no establishment of the holder of the design in the European Union, then we must consider this design as a national design of the country where the office is located. That means Spain, because as we have seen, the office is located in Spain. And in the designs, we have also rules on jurisdiction. We have rules that are equivalent to the rules in trademark, in European Union trademark. So, for example, in Article 79, we see that there is a reference of the application of the Convention on Jurisdiction and Enforcement. This is the Brussels Convention, but nowadays we have to change this reference to the Brussels Conventions to the regulation Brussels 1 bis. So here the regulation on the European Union design is saying that we are going to apply the regulation Brussels 1 bis. I repeat, the reference in the article is Brussels Convention of 1968, but as the Brussels Convention of 1968 has been replaced by the European regulation Brussels 1 bis, we are going to consider the application of Brussels 1 bis regulation, but with some exceptions. So at the end, the articles of the Brussels 1 bis regulation that are going to be applied are only few of them, and then there is a specific regulation in Article 82. So we must take into consideration Article 82 and complete Article 82 with the articles of the Brussels 1 regulation that are incorporated in Article 79. Well, maybe it seems more complicated than in reality is. There are rules in the regulation, Article 82, and and these rules of the regulation must be complete with certain articles of the regulation on jurisdiction, regulations Brussels 1 bis. This is the idea. The rules of the regulation in international designs are in Article 82, and things that are not covered with this article or completing this article are implied that we are going to take into consideration the regulation of Brussels 1b in the terms of Article 79. And which are the specific rules in Article 82? Well, it's very easy because it's the same that in regulation on trademarks. There is a general rule that is the general rule in international litigation that is the jurisdiction of the courts of the state, member state, where the defendant is domiciled. If the defendant is not domiciled in a member state, then we are going to give the jurisdiction to the courts of the member state in which the defendant has an establishment. This is Article 82.1 of the regulation. When the defendant is neither domiciled nor has an establishment in any of the member states, the proceedings, the jurisdiction goes to the member state in which the plaintiff is domiciled, or when the plaintiff is not domiciled in a member state, where the plaintiff has an establishment. And when neither the defendant nor the plaintiff have neither the domicile, neither an establishment in a member state, then the jurisdiction is for the courts of Spain, because in Spain is located the office, as we can see in Article 82.3. There are some other regulations, but I'm going to take into consideration that point 5, 82.5. Proceedings in respect of the actions clearly referred to in Article 81.a and d may also be brought in the course of the member state in which the act of infringement has been committed or threatened. So, when we are dealing with these actions related with infringement of the right, then we have a competence, we have jurisdiction in the country where the harm occurred. This is, at the end, if we pay attention, we are in the same idea with the same principles that we have seen in torts and that are very common in tort law. The idea is, on one hand, we have a general ground of jurisdiction. In that case, that general ground of jurisdiction is or the domiciles defendant or the domiciles the domicile of the defendant or the domicile of the plaintiff, and when the domicile is not in a member state, then the establishment of the defendant or the establishment of the plaintiff, and a specific ground of jurisdiction based in the harm, the place where the harm occurred. And this is very common in tort litigation. A general ground of jurisdictions linked usually with the defendant, but in that case also with the plaintiff when the defendant has no domicile nor establishment in the European Union, and another ground of jurisdiction based on the place where the harm occurred. This is the idea that we find here in Article 82 of the regulation. So this is what I wanted to explain related with designs. I repeat the main ideas. Sorry for this repetition. It's difficult for me because I'm not seeing your faces, so I cannot realize whether you are understanding or not, you are having problems or not. So maybe I'm going to repeat things more than in class, but I think that it's better. In any case, as we are in a video, you can go faster in one point and go back in another point. So that's another possibility. So now I'm to put clear the ideas, we have here related with grounds of jurisdiction the two main possibilities according with Article 82. A ground of jurisdiction based on the defendant's domicile. When the defendant's domicile is not in a member state, then we are going to consider the establishment of the defendant in a member state. When neither the domicile of the defendant nor the establishment of the defendant is placed in a member state, we are going to consider the plaintiff's domicile. And when the plaintiff's domicile is not in a member state, we are going to consider the establishment of the plaintiffs. When neither the domicile of the plaintiff nor the establishment of the plaintiffs is placed in a member state, then the jurisdiction goes to Spain because the office is located in Spain. This on one hand. On the other hand, we have also the possibility to introduce the claim before the courts of the place where the harm occurred or the place where the infringement is threatened, could occur. This is the specific ground of jurisdiction. These are the rules in Article 82, and we must also pay attention to the articles of Brussels I regulation that could be applied according with Article 79. But we are not going to enter into the detail of this article because at this level we are only trying to have a general idea of how the jurisdiction rules occurs. And related to the applicable law, we have a specific regulation in the regulation, sorry for the repetition, Article 88 of the regulation introduced a rule on applicable law. I hope that this is clear. So, this is in connection with European Union designs, the designs that has a territorial scope covering the whole European Union that are conferred by an European Union office located in Alicante. But remember, we also have national designs. And when we are dealing with national designs, we are dealing with designs different in Spain, in Italy, in Germany, or in France. And these designs, these intellectual property rights, are conferred by the authorities of these states. And in litigation related with these national designs, we must apply Regulation 1215 2012, Regulation Brussels I bis, in the same way that we have seen in relation with trademarks. So in that case, we have to distinguish between infringement and validity of the right. If we are litigating about the validity of the right, we must base the jurisdiction in Article 24 of the regulation, the exclusive ground of jurisdiction. The exclusive ground of jurisdiction that connects the claim with the country where the registration has been made. This is the idea. And this is for validity. And when we are talking about infringement of the right, we take special consideration to the defendant's domicile, and the place where the harm, the infringement occur or could occur. This is the specific ground of jurisdiction. This is, I repeat, when we are talking about national designs. In that case, I repeat, exclusive ground of jurisdiction for validity, Article 24 of the Brussels I regulation, and Articles 4, 6, and 7, also 8, but the most important articles, 4 and 7 of the Brussels I regulation, Article 4, the defendant's domicile, Article 7.2, the specific ground of jurisdiction for torts. But this ground of jurisdiction doesn't apply in principle for European Union regulation. In European Union regulation, we must consider the rules we have seen previously. Article 82 of the Regulation 6 2002 and Article 79 of the same regulation that, remember, the rule is that we are going to apply through this Article 79 some articles of the Brussels I bis regulation. Is that clear? Well, I'm expecting your answer. So if you have any doubts, you can contact me. This is in relation with I will see that designs. The other part, we are entering in a new part, is unfair competition. Now we are starting with unfair competition. Well, we are not going to enter in what unfair competition is, because I guess that you have studied that in commercial law. The very, very general idea is that market is an essential tool for economy, no doubt. And when we want that things go well, we need a perfect market. A perfect market means that all the participants in the market have all the information. The transactions are there are no the delay in the transactions. There are no way for trying to cheat the other participant in the market. So this is a market that doesn't exist. Obviously, we are always talking about a perfect market, but the perfect market doesn't exist. So we need some rules in order to make the market better, to avoid these behaviors inside the market that are pulling away the market from this ideal perfect market. And rules on unfair competition are very important in the sense that they are prohibiting some behaviors of the participants in the market that are against the rules of the market. If we don't have rules in unfair competition, maybe some of the participants in the market, persons or companies, will take advantage from an illegal, unjust way. And in that case, the market is not working properly, and the market is not achieving its goal, a perfect distribution of goods and services at a fair price. This is the idea. So each country has regulation on unfair, well, I don't know, every country in the world. Of course, the countries in Europe has this regulation. There are also European regulations, and it's commonly admitted that any modern market, any market in a developed country needs rules on unfair competition. What we have, so national rules, and we have also an approach from the point of view of the European Union. And here we have directives of the European Union that have been transposed into the law of the European Union member states. That means we have different national laws in the European Union member states related with unfair competition, but these rules are similar because all of them are inspired in the European Union directives. This is the idea. And which directives are these? Well, in first place, we have a directive 2006/114 concerning misleading and comparative advertising. This is a directive about misleading and comparative advertising, one of the aspects of unfair competition. So we don't have in the European Union a general directive covering all aspects of unfair competition. We have two important directives covering some important aspects of unfair competition. One of them is this Directive 2006/114 concerning misleading and comparative advertising, and the other one is the Directive 2005/29 concerning unfair business-to-consumer commercial practices in the internal market. This is a directive addressed to the relationship between professionals and consumers. This is another important aspect of unfair competition, not only covering the relationship directly, the relationship between professionals, but also the relationship between professionals and consumers. This is important because when the relationship between a company, a professional, a business enterprise with the consumers is not fair, this implies an unjust, a profit not correct for that. Could imply, not always, but we are facing the risk when there is not when we have a relationship between the company, the professional, and the consumer not fair, not according with the rules, then maybe the company is taking an unjust profit of the consumer. And this is not only bad for the consumer, but it's also bad for the market because the other professionals working in the market are in a disadvantage in relation with the person who is not following the rules. When somebody in the market is not following the rules, this is not only a harm for the consumer in that case, but also a harm for the other persons in the market. So this is one of the reasons that explain the relationship between the professionals, the business enterprises with the consumers. It's very, very important for the market and are a very important part of the rules of unfair competition. So we have this very important directives in the European Union, and these directives inspire the national law of the member states. And we are going to see just for a moment some behaviors that are covered by these rules, taking into consideration the Spanish law on unfair competition, the law 1991 of 10th January, that is the Spanish law on unfair competition applying to domestic cases. It's not a law addressed specifically to international cases, to domestic cases. But we are going to see some examples of behaviors that are against this law in order to see what we are talking about when we are talking about unfair competition. For example, there is a prohibition of acts of confusion when one of the persons working in the market introduce a confusion between the products, their own products, and the products of another person working in the market. There is also a prohibition of acts of deception, acts that could mislead people, that could in some way cheat people. People could arrive at a not correct idea about the product of the service. There is also a regulation about gifts and premiums given to the consumers, because in some cases this kind of practice could not be according with the rules, which can mislead the consumer. There is also a prohibition of acts of denigration of the other persons in the market. A regulation of acts of comparison to compare the product of one of the persons working in the market and the person of others business enterprises in the market. There is a specific regulation about violation of secrets. I remember that when we were talking about patents, we have seen that there is when we have an invention, there are two possibilities to protect that invention. One of these possibilities is the patent, the international property right granted by a patent, but you can also maintain that invention as secret, and then you don't have the protection of the patent, but you have the protection of the unfair competition rules. These rules we are considering now. So when some person in the market uses secrets of another person in the market, then there is a violation of the rules about unfair competition. This is always well, as we are not dealing with invention registered in a public office, of course we can face some problems of proof to demonstrate that really what the other person in the market is doing is violating a secret. These are problems of proof, but of course there are cases. I have in mind one case some years ago, many years ago in fact, involving two teams of Formula One, the car races. It was a a case involving Ferrari and McLaren. And I think that it was McLaren who copied some secrets of Ferrari through a person working for Ferrari. And I remember that if my I'm not pretty sure now, because I think that it was more than 10 years ago for sure, that one of the employees of Ferrari tried to copy some of the plans of a new car or some element in the car, and the bad luck for this man was that he went to a shop where one of the employees of the shop was a tifosi of Ferrari. And when that employee saw what was happening, he gives the information to Ferrari, and then Ferrari introduced a claim against McLaren. That was, I think, 30 years ago. So there are cases of violation of secrets between companies, and I think that this is a good example. Of course, you are not going to patent a system for a Formula One car. It's better to maintain it in secret due to the conditions of the competition. And there is also, and it's also interesting, another behavior that is prohibited by the rules on unfair competition, the infringement of rules. That is, it's not allowed to obtain an advantage through an illicit, through illegal means. And we are going to deal with that in some minutes. And there is also two more behaviors. There are more behaviors, but just to see a set of behaviors that are prohibited by the rules on unfair competition. The discrimination between consumers. This is against prohibited by the rules on unfair competition. And the sale at loss, to sell under the price you have paid by the goods, it's also a behavior prohibited by the rules on unfair competition. So this is just examples of the behaviors that are prohibited by the rules on unfair competition. And this is the approach from the domestic law point of view, the commercial law. But as we have seen the first day of the course, here is a course of international commerce law, so we are going to focus in the international perspective. We are going to focus in the problems in the international arena. And once we have seen that in a very, very general way what is unfair competition and how it's regulated in the different countries in the European Union, we are going to go through the regulation in the international field. And what we are going to see in this field of international unfair competition? Well, as we have seen till now, two different problems: international jurisdiction and applicable law. International jurisdiction, that means when we have a claim related with unfair competition connected with different countries, in which country we are going to introduce the claim. This is one of the points. Sorry. And the other point is when a court is deciding on the merits in a claim based on unfair competition, which will be the applicable law to that claim, to give a decision on the merits of that claim. Applicable law, jurisdiction and applicable law. Jurisdiction. Well, we are here again with our old friend regulation Brussels 1 bis, regulation 1215/2012. We have seen already this regulation. Here we must consider some articles we have already seen, that is articles 4 and 7. 4 and 7, mainly 4 and 7. 4. The ground of jurisdiction based on the defendant's domicile. We have seen a lot of times, if we have a claim in unfair competition, we can introduce the claim before the courts of the member state where the defendant is domiciled. This is the idea. And what happens when the defendant is domiciled in a non-member state? Article 6. Article 6, according with Article 6, when the defendant is not domiciled in a member state, the defendant's domicile is in a non-member state, then when we introduce the claim in a member state, the courts of that member state will apply its own domestic law in order to determine the competence, to determine the jurisdiction. So if we introduce a claim in Spain against a United States company, then the courts in Spain are going to apply the domestic law in Spain, Ley Orgánica del Poder Judicial, in order to determine whether they have competence or not. This is the first idea. Grounds of jurisdictions based on the defendant's domicile. When the defendant domicile is located in the European Union, then the courts of that state are competent, they have jurisdiction. When the defendant is not domiciled in a member state, then each member state, the courts of each member state will apply their own domestic rules in order to determine the competence, in order to determine whether they have jurisdiction or not. This is one set of rules, grounds of jurisdiction. But it's also very important to consider the ground of jurisdiction of Article 7, of Article 7. 7.2, torts. Article 7 covers different issues, different topics, contractual obligations, torts, also branches, and so on. In unfair competition, mainly we're going to focus in torts, because usually the characterization of an unfair competition infringement is a characterization as tort. So we must pay attention to Article 7.2 of the Brussels 1 bis regulation. And according with Article 7.2, in matter relating to tort, delict, or quasi-delict in the courts, the jurisdiction relates in the courts for the place where the harmful event occur or may occur. This is the idea. And then we must consider the case law related with this article. Which case law? Well, there are a very important decision of the European Union Court of Justice, Minas de Potage d'Alsace. I'm looking for this decision now. I want to try to find it. Okay, I think I have found it. Yeah, it's a judgment of November 30, 1976. And in this case, the problem, probably you already know this case. This is a very famous case. The problem results of the contamination of a field in the Netherlands. And the contamination of this field in the Netherlands was caused by the water coming from the Rhine, the very important river between France and Germany. And in that case, the contamination of the Rhine was caused by a company placed in France, in Alsace. So that company contaminated the river in France, and the contamination goes through the Rhine till the Netherlands. And in that case, the doubt was, well, when we are talking about the place of the harm, we are talking of the place where the damage occurred, or we are talking about the place where the event which gives rise to the damage occurs. And this is a very important question, because if we consider the first possibility, we will have the jurisdiction in the Netherlands. If we follow the second possibility, the ground of jurisdiction will give jurisdiction to the courts of France. In fact, will not give jurisdiction to France for a technical question. I'm not going to enter in that now, because our problem now, our interest now, is a different one. I'm just trying only to point out that there was a doubt about where the harmful event occurred, a doubt about where to locate the place where the harmful event occurred, when there is a dissociation between the place where the event which gives rise to the damage occurred, in that case the contamination of the river, and the place where the damage occurred, in that case the contamination of the fields placed in the Netherlands. This is the idea. When there is this dissociation, we have a doubt about when we can introduce the claim, in the place when the event occurred, or in the place where the damage occurred. The European Court of Justice says that we can use both of them. That means that we can consider the place where the damage occurred, and we can take into consideration also the place where the event giving rise to the damage occurred. This is an option for the plaintiff to introduce the claim in any of these places. And this is interesting. This is an advantage for the plaintiff, because the plaintiff has the possibility to choose two different jurisdictions, and these jurisdictions are even added to the jurisdiction coming from the defendant's domicile. Remember, we have always the possibility to introduce the claim where the defendant is domiciled. And we have another possibility to use the specific ground of jurisdiction of Article 7.2, and this ground of jurisdiction allows us to choose between different courts. So the possibilities for the plaintiff are many, as you can see, or could be many, considering the circumstances of the specific case. But this was not enough for some people thinking that the plaintiff should have more possibilities. I mean, what happens when there is an indirect harm? indirect harm. So there is a decision, a judgment of September 19 September 95, the case Marinari, that is interesting because in that case the direct harm occurred in England, in the United Kingdom. Well, I'm sharing with you the case so you can see the details of the case, but the person suffering the damage, Marinari, was an Italian citizen living in Italy, and he tried to introduce the claim in Italy, saying that he has suffered financial damage in Italy according with the fact that his residence was in Italy, and following this idea, the damage suffered by him was suffered in Italy, the place of his residence. So he tried to introduce the claim in Italy, and there was a doubt, thinking, well, we know that we can introduce the claim where the event giving rise to the damage occurred, the contamination of the river, where the damage occurred, the contamination of the fields. But what happens when the damage is to a person and that person claims that the damage occurred in the place of residence? When there is an indirect damage linked to the resident of the claimant. And in that case, the European Court of Justice, European Union Court of Justice, before being the European Union Court of Justice in the times of the European Community, said that the term place where the harmful event occurred in Article 5.3 of the Convention of 27 September 1968, but this is equivalent, this Article 5.3 of the Convention of 1968 is equivalent to Article 7.2 of the Brussels 1bis regulation, does not cover the place where the victim claims to have suffered financial damage following upon initial damage arising and suffered by him in another contracting state. So that means that indirect damage is not covered by the Article 7.2. Only direct damage is covered. So the possibilities of the plaintiff are many, but are not all the possibilities. At the end, I said that the plaintiff always tries to introduce, many times, tries to introduce the claim in his or her own resident. And this way, saying, well, there is a ground of jurisdiction based on the fact on the place where the harm occurred, and as I have suffered in my person the damage, where I live is the place where the damage occurred. And the European Court of Justice said this doesn't work in this way. This doesn't work properly in this way. We must consider that indirect damage are not covered by Article 7.2. Is that clear? There are many other cases in the European Union about that, but I think that these are the leading cases for the problem we are facing now, because these cases reinforce the idea that we can use the place where the event giving rise to the damage occurred and the place where the damage occurred, but not the place where the indirect damage occurred. And of course, when we are facing reality, this is very difficult to determine in some cases. But these are the main ideas, the principles we should follow. Again, is all that clear? Sorry for this question in blind to all of you. And well, we are now almost finishing this part of the this video that is being longer than I thought. I'm going to explain a real case. I will demand you to think about that case, and after that I'm going to give to you the case. You have to answer and send me the answers before well, preferably Tuesday and Wednesday, because I need to read your answers and to prepare another video to share with you on Friday. So if you send me your answers between Tuesday and Wednesday, it will be better for me, because on Thursday I can read then and to prepare the video to share with you on Friday. So this is, but it's not still the moment. We are going to see some questions before that. This is international jurisdiction. Applicable law. Well, applicable law, we must take into consideration Rome II regulation. Rome II regulation, the regulation in the on law applicable to non-contractual obligations have a specific rule on unfair competition. Article 6.1 and 2. 6.1. The law applicable to a non-contractual obligation arising out of an act of unfair competition shall be the law of the country where the competitive relations or the collective interest of consumers are or are likely to be affected. So, the first idea is that the law that we should apply is the law of the market affected, the country which market is affected by the acts of unfair competition. This is a very important idea in international unfair competition law, the mark affected, to determine which national mark has been affected by the behavior, and then we are going to apply that law. This is the first idea. But 6.2. Where an act of unfair competition affects exclusively the interest of a specific competitor, Article 4 shall apply. That means that when we are in a claim between two parts, when the damage has been suffered by one competitor in the market, then we are not going to apply the rule of Article 6.1, but the general rule of Article 4 of the Rome II regulation. And in many cases, we are going to face this kind of actions in which one competitor is affecting, is creating a damage, is causing a damage to another competitor. And in that cases, as established Article 6.2, we are going to apply the general rule of Rome II regulation, Article 4. And Article 4 is a very complicated article. So if you are trying to read, well, you should read the article, of course, but I think that we must explain the article in a different way that is written. It's not only my opinion, it's the opinion even of persons who have worked in the preparation of this regulation. For example, Professor García Martín Alférez of the Universitat Autónoma of Madrid, that was one of the persons involved in the writing of this regulation, in the elaborating, the creation of this regulation. So, if we see Article 4, the rules we have is that The first one, the habitual residence or the person claimed to be liable and the person suffering damage. This is Article 4.2. It's not at the beginning, but it's the main rule. When the person claimed to be liable and the person suffering the damage have their habitual residence in the same country, we are going to apply the law of that country. This is the idea. When this doesn't happen, and there is no habitual resident of the person claimed to be liable and the person sustaining damage, the person suffering damage, then we must apply Article 4.1. And according with Article 4.1, the law applicable is the law where the damage occur, irrespective of the country in which the event giving rise to the damage occur, and irrespective of the country or countries in which the indirect consequences of that event occur. This is important, and as we have seen previously, the doubts related with jurisdiction, maybe we are now in a best position to understand this rule of Article 4.1. Why? Because when we have seen jurisdiction, we have seen that there is a doubt between the place of the event giving rise to the damage, the place of the damage, and the indirect effects of the damage. And we have seen that according with the case law of the European Union Court of Justice, in jurisdiction we can choose between the place where the event giving rise to the damage occurs or the place of the damage, but not the place of the indirect damage. Well, here in applicable law we have to apply the law of the damage, not the law of the place where the indirect damage occurs, and nor the law of the place where the event giving rise to the damage occurs. In applicable law, we are going to take into consideration the middle, not the place where the event giving rise to damage occurs, nor the place where the indirect damage occurs, but the place of the damage. For example, in the case of Mines de Potash d'Alsace, the applicable law would be the law of the Netherlands, because S is the place where the damage occurred, and we wouldn't apply the law of the French law, the place where the damage occurred, when the event giving rise to damage occurred, or any law connected with the indirect damages coming from the damage in the Netherlands. This is the idea. The difference between jurisdiction and applicable law. Is that clear again? Well, and now the case. Well, first of all, I want you to pay attention to one real case between a Spanish company, Repsol, and an American company in relation with a case in Argentina. Repsol YPF case. Well, I'm giving to you some pictures about the case, and I'm committing you to take a look at that case. I think that it's a very interesting case. The idea is that Repsol is a Spanish company, and Repsol was the owner of the shares of an Argentinian company, YPF. Repsol, it's a company devoted to oil, extraction of oil, distribution of oil, and all these things related with energy. Repsol, through YPF, I think that it's better to say that YPF, the Argentinian company who was controlled by Repsol, found the way to exploit a very important field of oil in Argentina. And after that, the government of Argentina renationalized the Argentinian company, YPF. So, at the end, the Argentinian company was controlled by the Argentinian government, the Argentinian state, and Repsol, the Spanish company, lost their shares on the Argentinian company. This was the first step of the case. Till now, nothing related with unfair competition. Simply with international investment, maybe, because there was a Spanish company with interest in Argentinian company, and the government of that country, Argentina, took the shares of the company, and the Spanish company lost the control on the Argentinian company. And the Spanish company, of course, wanted a compensation for that shares. There was a compensation, but as always happened in these cases, the discussion was because the compensation was the compensation that the Spanish company thought that was fair was higher than the compensation really offered by the Argentinian government. And the discussion was in that point, the point of the compensation for the shares of the company. The Spanish company wanted a higher compensation, and the Argentinian company offered a compensation lower than the compensation demanded by the Spanish company. But this is still not a case of unfair competition law. How did a case of unfair competition law started? Well, it started when the Argentinian company, YPF, reached an agreement with a United States company for the exploitation of the oil fields in Argentina. So the idea is the Argentinian company had the fields, the oil fields, but the Argentinian company had no technology for the properly exploitation of that fields. The Argentinian company needed the help of another company in the business of oil in order to have the technology that they need for obtaining the oil coming from that fields. And the Argentinian company reaches an agreement with a United States company. And then the Spanish company introduced a claim before the Spanish courts against the United States company. Well, why? Because the idea was that the United States company has taken profit of an illegal act. The argument of the Spanish company was the expropriation we have suffered in Argentina was illegal. It's not important whether it was really illegal or not. The argument was that the expropriation was illegal. The taking of the shares of the company by the Argentinian government was against the law. And this illegal act was, better say, and the American company, Chevron, took an advantage of this illegal act because Chevron has obtained the access to the oil fields in Argentina thanks to the illegal expropriation of the shares of the Spanish company, of the shares of the Argentinian company owned by the Spanish company. This was the idea. This is a case of unfair competition because, as you sure remember, at the beginning, I have explained to you that the taking profit of an illegal act is against the unfair competition rules. And this was the argument of the Spanish company. The American company was taking profit of an illegal act. So the action was not against the Argentinian company. Well, that was also against the Argentinian company. But the main point is that they was litigating, the Spanish company was litigating against the American company. And the claim was introduced before the Spanish courts. And well, the Spanish courts had jurisdiction. The defendant was domiciled in the United States. Well, first of all, this is a case in which we cannot apply the Article 4 of the Brussels 1 bis regulation, because the defendant is not domiciled in a member state. As the defendant, the American company, was domiciled in the United States, Article 4 doesn't apply. We must take into consideration Article 6. And according with Article 6, the Spanish courts should decide their jurisdiction according with the domestic Spanish law, Ley Orgánica del Poder Judicial. By Ley Orgánica del Poder Judicial is very similar to the Brussels 1 bis regulation. But it's important to stress that we are not applying the Brussels 1 bis regulation rules on tort litigation, but we are applying Ley Orgánica del Poder Judicial. And we are applying Ley Orgánica del Poder Judicial because of Article 7 of the Brussels 1 bis regulation. And the ground of jurisdiction in Spain was almost the same that in Brussels 1 bis regulation, the place of the damage. And the doubt is, Spain is the place of the damage in that case, because the damage, the event giving rise to the damage was the contract between the Argentinian and the United States company. So a company in between two American companies, one South America, one North America, in relation with an oil field in Argentina. So, which is the relationship with Spain? At the end, the relationship with Spain is just that we are the company suffering the damage, the claimed damage, is a Spanish company. And at the end, the argument of the Spanish company is the same that we have seen in Marinari. The argument was that as the company suffering the damage is a Spanish company, the Spanish company is placed in Spain, and so any damage to that Spanish company is a place that can be located in Spain. Well, I think my personal point of view is that this is not a good argument, because at the end, if we follow this argument, any company can demand in their own country based on that argument, the argument that as they are suffering the damage in their own place of establishment, of domicile, of the residence, whatever you want, the courts of that state have jurisdiction. And at the end, all the courts and all the cases, at least in all cases, in this case related with torts, the courts of the plaintiff's residence will have jurisdiction. This is usually not allowed. There is even a Latin term for that, forum actoris. Forum actoris, that means the ground of jurisdiction based on the plaintiff, and usually this is considered not a fair ground of jurisdiction, because it's favoring the plaintiff, the actor, the claimant, and usually the grounds of jurisdiction must be in accordance with the defendant or in accordance with the place where the events occur. And if we consider that the events in that case occur in Spain because the company is placed in Spain, at the end, as I have said, we are facing a forum actoris. A forum actoris, a ground of jurisdiction based on the plaintiff, and this is usually considered not fair. From my point of view, the ground of jurisdiction based on the damage could lead us to Argentina or to the United States, the defendant's domicile, but not to Spain, my personal opinion. But at the end, the Spanish courts decided that Spain has jurisdiction, decided that Spain had jurisdiction in this case. And some weeks after that, the Argentinian government and Repsol reached an agreement on the price of the shares. I think that it was not completely disconnected, the agreement, and the fact that the Spanish courts decided that they have jurisdiction in the case against the American company. Well, I don't know if I was clear in that case. As I have said, you can put me questions through mail, and we can even have a meeting through I'm looking now for the case I'm going to put to you today, through Skype, and now I'm going to give you the case I want you to answer in the next days. I'm trying to find it now. I have that in my computer. Yeah, and I'm going to put them here. Well, it's a case that, as you are seeing now, it's very connected with the things we have seen today. So I hope that answering this case, you are going to have an idea about what we have discussed. And with your answers, I will have an idea about your comprehension of this topic of unfair competition. So I'm giving you this case. You have this case now in the video. I'm going to share you also this case through the Moodle. And as I have said, if you have any doubt, you can contact me through mail. And next Friday, I will give you another video. Thank you for being there. And so I don't find the word, and I'm so sorry for the situation we are facing now here in Spain, and especially for you foreign students that are here and that are not following the course in the circumstances we want. I hope that with our best efforts we can at the end follow the course till the end. Thank you for your attention.